Thank you for coming today. I'm attorney Gloria Allred. On my right is my client, Paul Peterson. On my left is my co-counsel, John Diley. Today we have filed a petition in Orange County Superior Court on behalf of our client, Paul Peterson, who is president of a minor consideration, AMC. Our petition asks the court to protect the financial interests and opportunities of Nadya Suleman Octuplets by appointing a guardian over the estate of these 8 infants. We are not seeking, nor do we desire to have custody of these babies. We have taken this action because we know that Nadya Suleman, as the mother of these 8 infants and their 6 siblings, has entered into contracts and received payments for still photos and videos of her octuplets. And she has stated that she will have a reality show with her children, produced by iWorks as well. She reportedly has said, quote, "It is going to be an ongoing thing, and it will follow them from now until they are 18, end quote. A minor consideration is an organization which for many years has been actively working to advance the interests and the rights of child performers. They have been successful in lobbying for laws which require that the earnings of children of all ages be protected and not spent or wasted by their parents or third parties, so that when a child reaches the age of majority, which is age 18 in California, they will be able to have access to and enjoy the fruits of their labor. In the case of the octuplets, rather than choosing to provide her children with a normal life, their mother, Nadya Suleman, has chosen instead to commercially exploit them. And it appears she plans to continue commercial exploitations of them in the future as well. Since she has chosen this path, we believe that the babies are entitled to remuneration, since much, if not most, of the compensation appears to be for the use of their images in print, on television, and on the internet. Our goal in seeking the appointment of a guardian is to be sure that the babies receive their fair share of the payments under the contracts which have required that their images be shown, and the payments under those contracts be placed into separate accounts for them and preserved for them as required by law. We also believe that a guardian can and will seek to hire a professional agent for the babies, different from the mother's representatives, to be sure that commercial opportunities are explored, even if the mother will not benefit from those opportunities herself. Most important, however, the guardian will assure that the children's compensation is fair and that their money is segregated and supervised. In other words, professional management will help to safeguard the baby's separate interests and rights. The guardian we have respectfully suggested be appointed by the court is Linda Rogers, a professional fiduciary who is licensed by the state of California and who is known and highly respected in Orange County, where the infants reside. She has agreed to assume the role of guardian of the octuplets estate if the court decides to appoint a guardian, and if the court wishes to appoint her to assume that important responsibility. The court has now given us a hearing date of June 22, 2009 at 1:45 p.m. for case number 30-200-0026518-PR-GE-LJC in Department L73 of the Orange County Superior Court, Lamoureux Justice Center, 341 The City Drive, Orange, California, for the first hearing in this case. We look forward to that hearing, but a contested hearing could be avoided if Ms. Suleman agrees with us that appointing an independent guardian for the estate of the octuplets to represent and protect their interests is a good idea. Ms. Suleman should realize that for the purpose of some commercial opportunities, she may have a legal conflict or an appearance of conflict with her children. Our plan will assure that there will be no question in the future that the baby's interests will be advanced and safeguarded, because a guardian for the octuplets will provide independent management and independent accountability. When the octuplets reach the age of majority, they will know that not one penny of earnings to which they are entitled has been spent by their mother or by anyone else. In addition to filing the petition with the court today, we have also sent a letter to the California Division of Labor Standards and Enforcement requesting an investigation into whether or not there have been violations of California law and regulations, which are there for the protection of child performers, including infants. It is our belief that any number of California labor laws and/or California regulations regarding children may have been violated by Ms. Suleman, potentially endangering the health, welfare, and safety of her children. For example, the law requires that when filming or photographing children takes place, that a nurse and a credentialed studio teacher or set teacher must be present at all times for infants 6 weeks to 6 months old. And I've cited the sections of the law. My clients, Angels in Waiting, and I were present when Ms. Suleman returned from the hospital on March 17, 2009, with 2 of her premature infants who were less than 2 months old. Filming of these infants by media who had contracts to film and video took place inside of Ms. Suleman's home on this date, but no studio teacher or set teacher was present. AIW nurses were also present on other dates when the infants were filmed, but no studio or set teacher appeared to be present. An important role of the studio or set teacher is to assure that the filming location is safe for the child performer and that all laws for their protection are being followed. That is the reason that the law requires that a studio or set teacher be present on the workplace set, in this case, the infant's nursery. Further, there are additional concerns regarding whether Ms. Suleman has complied with the state-mandated hours that a child can work. Specifically, children ages 15 days to 6 months may only work 2 consecutive hours between 9:30 a.m. and 11:30 a.m. or between 2:30 p.m. and 4:30 p.m. And I've cited the section of the law. According to state law, actual work may not exceed 20 minutes under any circumstances, and I've cited that law. On March 17, 2009, Angels in Waiting and I were present when 2 of Ms. Suleman's premature infant octuplets, born on January 26, 2009, came home from the hospital. We personally witnessed them returning to Ms. Suleman's home with her at approximately 10 o'clock p.m., and from that time until 11:50 p.m., they were filmed continually by an entity with whom Ms. Suleman has a contract and others in violation of work hour regulations previously cited. I commend Mr. Peterson for all of his important work in the past to protect child actors. He has benefited so many child performers in the past, and once again, he hopes to confer a benefit on these precious little infants by asking the court to protect their financial future. My co-counsel in this case is the Diley Law Firm. John Diley and his partner Cynthia Rawle are prominent, experienced, and highly regarded probate attorneys in Orange County, and we look forward to working with them on this case. And now it's my pleasure to introduce Mr. Peterson, who is president of the Minor Consideration, very active in many other ways, but is doing this as an interested person.
Thank you, Ms. Allred, and thank you all for coming today. Thank you too, Mr. Diley. Those of you who have followed my 30-year journey as an advocate for children working in the entertainment business are probably not surprised to see me here today. I am here today because I am concerned with the health, welfare, and safety of the Suleman Octuplets. A rational person might ask, where are the laws that protect these infants who are trapped in a situation they cannot possibly comprehend? They are now working in the entertainment business. And even though they cannot walk or talk, they are, like all children in the entertainment business, protected under California law. The Preemie Bill, Assembly Bill 744, was passed in 1998 by a unanimous vote of the California legislature and signed into law on August 3, 1998, to protect against Hollywood's then growing practice of hiring premature, multi-birth babies.